features Anna St. John, nominated to the U.S. Court of Appeals, Fifth Circuit. Our second panel has Gregory Cook, be judge of the U.S. District Court for Northern District, Alabama. Adam Coney-Dube to be Assistant Attorney General for the Antitrust. John Cronin and Jason Mannion to be Commissioners on the U.S. Sentencing Commission. All of today's nominees are highly qualified and reflect diverse backgrounds in law and public service. They continue President Trump's trend of nominating top-tier people for our country's most important roles. I have a personal honor today to introduce three of our five nominees, so I'll do that right now. Adam Coney-Dube is nominated to serve as Assistant Attorney General to oversee the Justice Department's Antitrust Division. His career spans public service, private practice, and academia. After graduating from Yale University and the University of Chicago Law School, he clerked on the Ninth Circuit and practiced law at two major firms for a better part of a decade. The nominee then entered public service as an attorney advisor at the Federal Communication Commission for the past, for the 2 decades thereafter. He was a professor at Michigan State University Law School, where he taught many areas of law, including antitrust and criminal law. Notably, at the end of President Trump's first term, the nominee briefly returned to public service as acting administrator of the National Telecommunication and Information Administration, and then as Deputy Attorney General with the Justice Department. During President's second term, the nominee has served as General Counsel of the Federal Communications Commission. Throughout his career, he's done important work. His scholarship and legal advocacy focused on protecting children from exposure to pornography and other obscene materials. He's also a strong advocate for free speech and fighting censorship by Social Security companies during the Biden administration. Next, Judge Cronin, been nominated to serve as U.S. Sentencing Commission. As a federal judge, he obviously knows a thing or two about the sentencing guidelines that the commission sets forth, and his understanding of criminal law stems from his career of public service. Before joining the bench, Judge Cronin served as Assistant U.S. Attorney for the Southern District of New York. He was also the chief of the Terrorism and International Narcotics Unit. Judge Cronin oversaw more than 100 investigations and prosecuted a wide array of crimes, including complex national security cases against foreign terrorists. His career featured additional positions with the Justice Department, serving as Principal Deputy Assistant Attorney General and Acting Assistant Attorney General of the Criminal Division. Since 2020, Judge Cronin has served on the U.S. District Court for the Southern District of New York. He's done a great job, and I thank him for his service. Finally, Judge Jason Mannion, has also been nominated to the U.S. Sentencing Commission. He brings a distinguished career that has spanned all three branches of government. After graduating from Harvard Law, Mr. Mannion clerked twice on the U.S. Court of Appeals for the Sixth Circuit. He served as Deputy Solicitor General for the state of Ohio, and he's also worked in support of this committee as special counsel for my colleague, Senator Cruz. Since 2022, Mr. Mannion has served as an assistant U.S. attorney for the Northern District of Ohio, and as a federal prosecutor, he's handled many cases and appeals dealing with sentencing issues and sentencing guidelines. During President Trump's second term, Mr. Mannion has held multiple significant roles on detail from the U.S. Attorney's Office, serving as counselor and chief of staff to the Associate Attorney General, and then the Attorney General, and he's currently a general counsel and senior advisor of the White House Task Force on Eliminating Fraud. Senator Durbin.
Thanks, Mr. Chairman. I've served on this committee for nearly 30 years. In that time, I've attended countless nomination hearings, providing an opportunity for members to determine if nominees are qualified. Nomination hearings like this one today are an essential part of the Senate's role in providing advice and consent on presidential nominees. This constitutional duty is a critical check on the executive branch, and it has never been more important that the Senate exercise this duty, because we now have a president and an administration determined to use every opportunity to push the bounds of power. I'm not going to revisit the nomination of Todd Blanche. We spent a good part of yesterday morning in this committee discussing his worthiness for that position. But I do want to say that there are some elements underway in this administration that need to be addressed by Congress, I hope, if not by the courts. Dramatic changes. Corruption. Corruption used to happen behind closed doors. Now the doors are wide open. You can see exactly what's going on. First year in office, second term for Donald Trump was a good year for him. $1.4 billion at least, some say $2 billion. An amazing, amazing amount of money for anyone who would be president of the United States. And unfortunately, the fingerprints on that $2 billion involves the crypto industry, cryptocurrency. They have their fingerprints on every act of corruption in Washington. And we see members of the cabinet, would-be members of the cabinet, with personal holdings who are trying to explain their relationship with the crypto bunch. Judges may ultimately make the decision on this. That's why nominees will be asked some important questions. Insider trading boost. Did you read about Truth Social? For $100,000 a month, just $1.2 million a year, we're going to give you the edge on information, official information from this administration. You may get 30 seconds. Maybe that's all you need to punch the right button on the computer and make a fortune. $100,000 a month. Was that sneaky, behind-the-scenes strategy? No way. It was advertised on the front page. Want to buy into this new information for insider trading? Give the president's company $100,000 a month. Does that sound right to everybody here? The third thing is U.S. attorneys. For the record, in President Trump's first term, over 80, almost 90, maybe I'm off a few, U.S. attorneys who were approved by this committee by voice vote and then approved on the floor by voice vote. I'm talking about Trump administration 0.1, 1.0. Now we go through each and every one of these U.S. attorneys and have a fight as to whether or not we're going to have the ultimate last word on their selection or whether they'll be acting U.S. attorneys indefinitely. That's a change. What brought it about? I'll tell you exactly what brought it about. The decision by one senator from Indiana, now Vice President of the United States, to require separate roll calls on every U.S. attorney under the Biden administration. He started it. I tried 3 or 4 times to get him to reconsider it and to go back to the bipartisan approach. He wouldn't do it, and now we're stuck with it. We spend more time on the floor voting for U.S. attorney nominees than we should. I hope we can return to the days where we trusted one another and didn't have this kind of arrangement. We're wasting our time in the Senate. In closing, I want to note that 2 of the witnesses before us have been nominated to fill vacancies in the U.S. Sentencing Commission. Congress created the Sentencing Commission in 1984, charged it with the critical task of promoting transparency and consistency in federal criminal sentencing. The Commission collects and analyzes data and then employs its expertise to help guide Congress in setting sentencing policy to guide the federal judiciary in making important sentencing decisions. Members of the Commission are tasked with the responsibility of establishing practices and policies that promote proportionality in sentencing and reduce sentencing disparities. They must carefully consider revisions to sentencing guidelines as they forever impact the lives of those facing the criminal justice system. The Commission has long operated in a bipartisan manner, a reflection not just of the statutory mandate for bipartisanship among Commission members, but also of the consensus-driven approach embraced by those who have served on this important body. During the Biden administration, I was proud to lead the effort to reestablish the Commission's quorum with a full bipartisan slate of nominees so that it could continue its important work. Federal judges rely on sentencing guidelines promulgated by this commission for one of the most important aspects of their jobs, deciding on the appropriate penalty for a defendant. Thus, it is critical that members confirmed to the commission have the technical expertise, experience, and understanding so that they can face the gravity of their work and understand its impact on the criminal justice system. I look forward to hearing from the nominees. Thank you, Mr. Chairman.
Senator Kennedy for introduction.
Thank you, Mr. Chairman. Judge St. John is no stranger to this committee. She was before us in February, where she was being considered for a position on the United States District Court in New Orleans, on which she presently serves. President Trump has nominated Judge St. John to fill a vacancy created by Judge Englehart, who has served honorably and well on the federal Fifth Circuit. The president chose wisely. Judge St. John's had an interesting career. She's from a small town in Mississippi. She went to LSU and just absolutely knocked the top out of it. Magna cum laude graduate. An assortment of law schools, predictably, tried to recruit her. She chose Columbia. She knocked the top out of it at Columbia. She got a JD and a master's. She was a James Kent Scholar. She then clerked for a year for Judge Barksdale on the United States Court of Appeals for the Fifth Circuit, very distinguished jurist. Then she went to work for one of the premier law firms in the world, Covington and Burling. At that level, when you practice with a firm is like Covington, it's not a job, it's a lifestyle. She was there 7 years. She would have been partner, which just means, well, it means you get to work harder. You also make a bucket load of money. But she and Scott were married, and she said, you know, I'm rethinking things here. I want to practice with a smaller firm and have a family, and not many people, not many lawyers would make that choice. I mean, you work so hard to get to become a partner. But there are other ways to contribute to the practicing of law. She has been in private practice with a small boutique firm. One of the things she specializes in is class actions. And thanks to her work, she has ensured that the people who are hurt and are the subject of these class actions, who oftentimes don't get any money, all the money goes to the lawyers, she has worked to ensure that people get their fair share. But more than than her accomplishments. Judge St. John is, she's obviously intelligent. She's patient. She's wise. She is not a politician. She didn't have a squillion people call me to encourage her nomination either for the Court of Appeal or for the district court. We do get a lot of those calls. She just applied. And I was going through the resumes and I saw hers and said, oh my God, I need to talk to this lady. And I checked around and she was obviously one of the most qualified. And that's why for the district court level and the Court of Appeals, I suggested her to President Trump. Judge St. John, she understands the law. She knows the law. But more importantly, she appreciates the beauty of the law, the elegance of the law, the nuances of American law, and the shortcomings of American law. I've met a lot of smart lawyers who know the law, but they don't really appreciate its application. They don't really understand the human consequences of its application. They don't understand, as I said, its beauty or its shortcomings. And so I'm happy to introduce Judge St. John. I talked longer than I thought. My work here is done. Mr. Chairman, I can show myself out.
Thank you, Senator Kennedy. Now, Senator Brett.
Always my favorite. Thank you so much, Mr. Chairman. It is an absolute honor today to be able to introduce one of Alabama's finest, Alabama Supreme Court Justice Greg Cook, who I am fortunate to call a friend. Welcome to you and your entire family. In my opinion, this day has been a long time in the making. For those of you who don't know Greg and haven't had a chance to read up yet, I am so delighted that President Trump chose Greg to fill the role there in the judgeship in the Northern District of Alabama. Greg has served at the Alabama Supreme Court as an Associate Justice since 2022. He has reviewed and written numerous opinions on some of the state's most complex, both criminal and civil cases that were in front of him. He has an impeccable record of service. So when you look at Greg and you see the way he conducts himself, he applies the law fairly and diligently to everyone who comes in front of him. Now, he's just been on the bench since 2022, but prior to that, he spent years at one of our most distinguished firms in the state of Alabama, 32 years to be exact, earning the rank there of partner. But prior to that, he served in the Air Force. Greg made the rank of captain and also continued to serve our nation in the Air Force Reserves. This is in his blood, love of country, service to those around him, in his community, and his family, and his state, and now for his nation. Greg graduated from Duke, also went on to Harvard Law, and despite the accolades that he's received in his life, the thing that has always been most important to Greg is his family. I say that's because of the values that were instilled in him and the Shoals growing up. He loves his children, he loves his wife, his church, his community, and he has consistently bettered himself to be able to answer the call. I had an opportunity about 4 years ago to really get to know Greg. We had traveled around the state together, and I got to see him interact with Alabamians. I got to see him connect with them, want to know what was happening and how he could be helpful. I also got to learn that he wrote Alabama Rules of Civil Procedure book, which was quite a thick book. That shows he not only knows the law, he loves the law. And I have every faith and confidence in his ability to answer this call. Greg, thank you for being willing to serve. You are such a fine human being. Your character is unmatched, your diligence, your intellect. I know that you will uphold the Constitution and you will apply the law faithfully in every single circumstance, and that you will be thoughtful about the role that you are stepping into in a way that's going to make every one of us proud. So thank you for answering the call. I urge all of my colleagues to vote for Greg, and boy, it was an honor to be able to send your resume forward. And I appreciate President Trump for seeing what I saw on that piece of paper and in this human being in front of us. So thank you, Greg, and thank you, Mr. Chairman, for allowing me to introduce him.
Thank you. Judge St. John's, would you please come? And before you seat, I'd like to administer oath. Thank you. Do you swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth? So help you God? Very positive response. Now you sit down and give your testimony and introduction of friends and family, however you want to proceed. It's the proceed.
Thank you. Thank you, Chairman Grassley, Ranking Member Durbin, and thank you to all members of the committee for having me here today. Thank you to President Trump for the great honor of this nomination. Senator Kennedy, thank you for those very kind remarks. No one could accuse you of being an easy grader, and so I'm just especially grateful for your support. I also want to thank Senator Cassidy for his support. I am here today with my husband, Scott. He's an exceptional person, truly my better half. He is sitting with our 3 older children, Charles, Bertie, and Anna Douglas. Our littlest and most energetic, Jack, is home with my parents-in-law, Joyce and Doug St. John. They have been wonderfully supportive over the years, and I'm very blessed to be a part of their family. I'm here today only because of the support of so many people. Those include my siblings, aunts and uncles, friends, and colleagues. Above all are my parents, Libby and Chuck Wagner. I wish they were still with us for so many reasons, but I know I didn't need to become a judge to make them proud. I just needed to be a good person. I continue to be inspired by their sacrifices and the values they live by. I'm also here today with my law clerks. I'm privileged to go to work every day at the U.S. District Court for the Eastern District of Louisiana. I serve alongside an incredible group of people. Those include my judicial colleagues, our court security officers, everyone in the court clerk's office, and so many more. Their hard work to make sure we have a strong, functioning, efficient judiciary is a testament to the strength of our country and its people. Being nominated to the Fifth Circuit is a profound honor on its own, made more so because that's where I started my legal career, clerking for Judge Risa Barksdale. I strive to put into practice the lessons I learned from that clerkship every day, and will continue to do so if I am so honored by being confirmed. Again, thank you for considering my nomination. I welcome any questions.
Judge, you've been serving as a district judge for just a few months now. You seem to be managing a docket, I'm told, of about 120 civil and criminal cases, so you got a lot shoved on you right off the bat. During your time so far, what's the most important thing that you've learned about being a federal judge?
Well, Senator Grassley, you're right. I really hit the ground running, and I learn more every single day. One aspect of the job that's really been impressed upon me is the impact that the court's work, that my orders have on the parties. As a district judge, you know, I see the criminal defendants right in front of me with their families. I see the pro se litigants and interact with them. I see clients with their attorneys. And it's really impressed upon me the need for judges to make sure that people have a full and fair hearing, that they feel that they're getting a fair consideration of their case, and that judges provide reasoned opinions so that the parties know, that people understand that the court's rulings are based in the law and not on any judge's personal preferences or beliefs.
I would think most people would agree with what Senator Kennedy said on your last confirmation. He said, quote unquote, you were a real student of the law. Beyond the law, you've spent years working with New Orleans Family Justice Center, and that center is dedicated to ending family violence, child abuse, and sexual assault. Tell us, please, why it's important for judges to prioritize victims and victims' rights when presiding in a case of that nature.
Sure. So judges and courts do represent the legal recourse that the more vulnerable in our society have access to. And so it's so important for courts and judges to be to uphold the law and be a source for enforcement and implementation of the law that's intended to protect our most vulnerable in society.
I think I'm going to quote something you said during your last confirmation hearing. You stated that, quote, the best way to give effect to people's will is by construing the words used in the text with the meaning these words had at the time they were enacted pursuant to the constitutionally prescribed lawmaking process, end of quote. Why is that approach so important?
That approach is important because our Constitution lays out the process by which law is created, and that requires bicameralism and presentment. What emerges from that process is the text of the law, and that text represents the will of the people as expressed through their representatives in the legislature. If judges are to add meaning to that or change the meaning of the text that was agreed upon through the legislative process as prescribed by the Constitution, that constitutes judges enacting their will rather than the will of the people. And so that's why it's so important for judges to, stick to the text of the law.
The next question and last question is something that I have a hard time with myself when people ask you, which is the most important colleague you've had or president you've served under. So tell us which attorney or judge you most admire and why.
Well, Chairman Grassley, I started my career clerking for Judge Barksdale, as I mentioned, and that was really a foundational experience where I learned how important it is to meticulously analyze each case and make sure you understand the facts and the law and have approached it with a truly impartial approach so that you are giving each party a fair shake. It's also important, I've learned from Judge Barksdale, to remember the role of the judiciary. We are not lawmakers. Courts have defined powers, and it's important for courts to stick within the powers that have been granted to the judiciary rather than taking powers beyond what they have.
Thank you and congratulations, Senator Durbin.
Judge St. John, welcome back. I'm not going to revisit many of the questions that I asked you several years ago when you appeared before us. I don't think your answers were responsive then. I don't expect they would change today. But there is one issue I want to return to. At your previous confirmation hearing, I noted that in November 2021, when I chaired this committee, we advanced the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act by voice vote. I believe that the sponsorship of this legislation was virtually unanimous, not completely, but close to unanimous, on the Senate Judiciary Committee. And of course, the membership of this committee embraces the American political spectrum from right to left. Virtually all of the members of the committee voted for this and supported it. Why? It was legislation that said to a woman, particularly, that you cannot be held by an employment contract which limits your options if you're a victim, allege that you're a victim of sexual assault or sexual harassment. Some employment contracts, and I know you're well aware of this issue, some employment contracts do not give a victim woman in that circumstance an option to take her case to court before a judge or a jury. It has to be by forced arbitration, and in many cases, the arbitrator is chosen by her employer. It creates a real disadvantage for those who are alleging that they're victims of sexual harassment. You testified in the House against this legislation, claiming that ending forced arbitration was, quote, not in the best interests of those subjected to sexual harassment and assault. You argued that the bill, quote, turns these women into unwilling pawns, leveraging their private difficulties in pursuit of public policy objectives that don't actually benefit them. You said at one point as well, arbitration is faster, less expensive way of resolving disputes companies may have, so they have more funds to devote to employee benefits or to lowering costs for consumers. Former Fox News host Gretchen Carlson was a leading advocate for the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act following her harassment by Roger Ailes at Fox. She previously opposed your nomination to the district court, and this is what she said. While women around the country bravely share the urgency of eradicating forced arbitration, St. John used her power and influence to gaslight these women and the public. She downplayed their stories and minimized their pain, instead of listening to women who were forced to suffer in silence. St. John tried to convince Congress that these women's understanding of their own experience were incorrect. These are the words of former Fox News host Gretchen Carlson. It's been several years since you've thought about this issue before one of these committees. Today is an opportunity for you to answer the question, do you have any second thoughts about the position you've taken on this issue?
Senator Durbin, I appreciate those questions. And I want to be clear. I think some of my words were taken out of context. I did not oppose the legislation. I didn't presume to tell any senator or Congress member how to vote. I understood my role as providing additional context about arbitration and additional information as Congress members worked through this issue and figured out where to draw the line on these issues and how to legislate. One of the comments you quoted from my testimony was referring to forced litigation. My point is that women should have a choice to choose to arbitrate or litigate. And I continue to think that there can be benefits to arbitration in some instances. There can be benefits to litigation. And at no point do I think anyone should be forced to arbitrate their claims. Arbitration is only by consent of the parties.
That's exactly the issue. There's no choice in forced arbitration. It's a take it or leave it for the employees before this new law was enacted.
I certainly respect that Congress carved out those claims from any kind of pre-dispute arbitration agreement. And I agree, even before the law, if an employer did force somebody to sign an agreement, then under the law, that should not be valid. And people should have a choice as to whether to take their claims to court if they wish.
I think it's a good response, but it really is inconsistent with the role that you played and the testimony you gave before the House of Representatives. So let me just ask you today, do you think forced arbitration of sexual assault and sexual harassment cases is right or wrong?
I don't think anyone should be forced to arbitrate their claims.
You've changed your position.
I've always taken the position that arbitration is by consent only.
Well, that is a dramatic change from where you were when you testified before Congress. Thank you, Mr. Chairman.
Before I call on Senator Kennedy, enter in a letter in support of the nominee from Melissa Holyoke, U.S. Attorney District of Utah. They work together on consumer protection litigation in private practice. The letter praised Judge St. John and stated, quote, as her colleague, I was consistently impressed by Anna's disposition while engaging with our colleagues, other counsel, and the courts. She would carefully consider differing viewpoints, approach opposing arguments with intellectual honesty, and always kept her composure during the circumstances, end of quote. Senator Kennedy.
Thank you, Mr. Chairman. Judge, your spouse, Scott's a pretty good lawyer in his own right, isn't he? Yeah, I'm sorry, I neglected to mention that when I was introducing you. This issue about your feelings about sexual harassment and the recourse of people who have been harassed seems to have arisen when you were testifying as a private citizen back in 2021 before the House, as I understand it. And I've read your testimony. I've read the record. I don't see how any fair-minded person can conclude that you were trying to do anything to impede someone who's a victim of sexual harassment from being able to address the wrongs. Here's a quotation from your testimony. Quote, your words, not mine. Allegations of sexual harassment and assault should be taken seriously, and accusers afforded the full protections of the law as they seek to hold those responsible to account. Removing one form of dispute resolution, however, does not further those goals. Did I read that correctly?
That is correct.
Now, if I am a victim of sexual harassment, I have a number of options. I can file a complaint and try to resolve it privately, if it's in the workplace, with my employer and the alleged perpetrator. Can I not?
Yes, you can.
Or I could choose to mediate the dispute, could I not?
Yes, Senator.
Or I could choose to arbitrate the dispute, could I not?
Yes.
Or I could choose to go to court, could I not?
That's correct, Senator.
Now, do you oppose removing any of those options for someone who's an alleged victim?
No, Senator. Victims should have their choice of how to deal with these issues.
And as I understand your testimony, you tell me if I read it wrong, but I looked at it pretty carefully. What you were saying is that, at least as I appreciate it, that all forms of redress should be available to the alleged victim, right?
Yes, Senator.
I mean, would you elaborate on that a little more? Because I honestly, I don't get it. I mean, I get the politics, you know, the folks that Democrat and Republican and all that, but my experience, you're not a very political person, and you were asked to come testify as a lawyer and an expert in the law, so tell me what you said.
Thank you, Senator. And when I hear these criticisms, it feels very disconnected from my actual testimony. I would never try to silence a victim of sexual assault or harassment. My point in my testimony was to provide some context for how many different options for resolving these claims and addressing these claims should be available to women. And forcing them into litigation or taking away their choice of one option or another is not actually supporting the victims, and Congress should do as it sees fit to make sure that these victims still have options for resolving these terrible events.
Okay. Well, let me be sure I understand your testimony. Do you consider acts of sexual harassment to be repugnant?
Yes, of course.
And do you support the right of anyone who claims to be sexually harassed to be able to have their allegations heard in accordance with the rule of law and due process?
Yes, absolutely.
In your testimony, did you support all forms of redress? Do you think we ought to preclude somebody from going to court or not going to court or arbitrating or not arbitrating or mediating or not mediating?
No, I didn't take anything off the table.
Okay, I didn't think you did. I read it pretty carefully. All right, well, thank you, Judge. I appreciate your candor. I'm done, Mr. Chairman.
By the temporary power vested in me, I recognize Senator Whitehouse.
Thank you, Mr. Temporary Chairman. I'm not going to be able to vote for this nominee, and I wanted to explain why. Her history with Hamilton Lincoln Law Institute, Center for Class Action Fairness, Competitive Enterprise Institute, and Independent Women's Forum creates concerns for me that she has simply for too many years inhabited the Leonard Leo, Koch brothers, judicial/political operation machine. I think that group of interwoven organizations has a very specific goal, which is to put people onto courts who, when the time is ripe, can be relied on to make the decisions that they want. And I don't think that's what being a judge is about. I don't think that's what this committee should be about. It has nothing to do with conservative versus activist. I think some of the most activist decisions that have been rendered have come from judges who've come out of that same Koch brothers, Leonard Leo network of judicial/political influence. Competitive Enterprise Institute, a frequent dark money amicus in courts, has taken roughly $10 million from Donors Trust and Donors Capital from 2012 to 2022, $400,000 from Koch organizations from 2014 to 2021, and its president became the president of Donors Trust in 2015. Donors Trust is described as the dark money ATM of the far right. Hamilton Lincoln Law Institute took at least $1.25 million in litigation grants from Donors Trust since 2021. Independent Women's Forum took $300,000 from Leonard Leo's Judicial Education Project in 2018, and more than $13 million from Donors Trust from 2017 to 2018. I don't know why Donald Trump called Leonard Leo a sleazebag. Something's going on that's a little weird there. But what I do believe is that a persistent effort by the far right wing, funded by a lot of billionaires who anonymize their money through Donors Trust and into front groups, is a very, very powerful force in judicial appointments right now. And Ms. St. John, I'm sorry to say that based on that record, I can't help but believe that when the time comes and the right amicus comes before you, that'll be the signal for you to render the decision that they want. So that's why I'm not going to be voting for this nominee. I'd also like to add, because it's just been in the news recently, comment on the situation with the U.S. Attorney, Janine Pirro, and the action that the District of Columbia U.S. Attorney's Office took in the reflecting pool case. We saw an awful lot of lying take place. For instance, the Secretary of the Interior just a month ago on CNN was asked about that lining. It peeled off. Why did that happen? Do you know? It didn't peel off, he said. There was vandalism, he said. There were box cutters, he said. The question came back, you're 100% sure that what happened with the liner was vandalism? You can prove it. Oh, yes, absolutely, he said. U.S. Attorney Pirro said the same thing in a big press splash announcing the indictment of the former Olympian against whom the charges were just dropped. Why were they dropped? They were dropped because the case ran into a wall based on a decision called Brady versus Maryland, which creates a constitutional duty on the government to disclose exculpatory evidence to anyone it is charged with a crime. And the U.S. Attorney's Manual, which they now call the Justice Manual, actually has a robust section directing prosecutors not just to adhere to the minimum constitutional standard, but to go out of their way to make sure that all exculpatory evidence gets delivered to the defendant. So the actual lawyers going to actual court were looking at having to turn over exculpatory evidence that, according to the U.S. Attorney's own pleading, was withheld from them by the Department of Interior. So a U.S. citizen was falsely indicted based on incomplete information, while the government, at least at the Department of Interior, held information that it did not disclose to the Department of Justice that would have blown up the indictment, that should have been disclosed to the grand jury. This whole exercise was disgraceful, and the fact that senior government officials still continue to lie about the vandalism after what they've seen just makes it worse. Thank you, Chairman.
Senator Blumenthal.
Thanks, Senator Durbin. Just say, John, you were here just months ago, February 4th, 2026, and I asked you a number of questions. I'm going to ask you the same questions, beginning with who won the 2020 election?
Senator, excuse me, pursuant to the 12th Amendment and Article 2, the electoral process is the process by which a president is selected. And in January 2020, Joe Biden was certified by the Electoral College and served for 4 years.
So you are unwilling again to answer that question truthfully, correct?
Senator, I've provided a response that is ethically appropriate and legally correct under
It is
the
ethically
Judicial Code.
inappropriate for you to fail to be candid with this committee and to give us the canned, rehearsed answer that you have been programmed by the Trump White House to provide. Let me move on. Was the United States Capitol attacked on January 6, 2021?
Senator, I have reviewed some testimony and news reports, some videos and news reports showing that there were some physical assaults on law enforcement, and I completely condemn any kind of violence against law enforcement.
Was the Capitol attacked?
You know, I want to be careful with the specific language I use because I am a federal judge and subject to
You're
the
a
codes
federal
of conduct.
judge, Judge St. John, but federal judges have not only acknowledged but stated clearly that the Capitol was attacked. Justice Amy Coney Barrett, in her dissent in Fisher versus the United States, said, and I'm quoting, "A mob of rioters that breached the Capitol on January 6, 2021, and that the rioters, quote, conduct, which includes trespassing and a physical confrontation with law enforcement, was part of a successful effort to forcibly halt the certification of election results." Do you agree with Justice Coney Barrett?
Well, I was going to agree that the Supreme Court has used the term "the Capitol was breached," and given that I'm subject to Supreme Court precedent and that's language that has been used by the courts, I'm comfortable adopting that language. Yes, Senator.
So you agree that the Capitol was attacked on January 6th?
You know, I want to be very careful with my language because this is a politically controversial subject, and I'm subject to the judicial canons. As you noted, the Supreme Court has described it as a breach of the Capitol.
Justice Barrett said that a mob of rioters breached the Capitol, and Judge Timothy Kelly, also a Trump appointee, said, quote, as the court has said many times, the attack on the Capitol on January 6, 2021 was a perilous event. It was an attack on people, including police officers, many of whom were injured. Do you think Judge Kelly is being less careful than he should be, calling it an attack?
I wouldn't be careful with my own personal response. And all of the attacks against law enforcement, again, I completely condemn.
You know, other judges have similarly acknowledged that there was an attack on the Capitol on January 6, 2021. I think it is fundamentally disrespectful to the Capitol Police who fought back against that attack. It is disrespectful to the truth of what happened on that day. But most important, it indicates that you are continuing, and emphasize continuing, to adopt the president's distorted and inaccurate illusion about what happened on that day that he has, in effect, used to try to rewrite history. And it indicates a lack of independence. I think that lack of independence is disqualifying for you to be a judge on the district court, not to mention the Court of Appeals. It's the reason that I voted against your nomination for the district court. But now that you are on the district court, you have a lifetime appointment. President Trump can't do anything to you. You have no reason to fear his vaunted vindictiveness against anyone who would defy his illusion about January 6th. And your failure to basically speak truth to this committee, I think, indicates that you will fail to speak truth to power if you are confirmed as a judge on the Court of Appeals. The rehearsed and regurgitated language that you've given us today, I think, is disqualifying, and I regret that you can't do better. Thank you.
There's nobody else to ask you questions, except I'm sure you're going to get a lot of questions for the record. Answer them.
Thank you.
Okay. If you'll, got one more nominee to come here. Then I'll administer the oath. I'd like to swear you at this point. Do you swear that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth? So help you God? All answered in the affirmative. Please sit down, and we'll start out with you, Mr. Cook, and go across. You can make your opening statement, introduce your family and friends, say whatever you want to do at this point.
Thank you, Mr. Chairman. I appreciate the time of everyone today on this committee. I want to thank President Trump for this nomination, which is the honor of my lifetime. I want to thank Senator Tuberville and Senator Britt, who lent their support and made this nomination possible. I want to thank my wife of 38 years, Kimberly, who has been with me every step of the way through my time in the United States Air Force, through law school, and through raising our 3 children. I am truly blessed. I would like to thank my parents, Gene and Dottie Cook. My dad, also an Air Force veteran, passed away when I was running for the Alabama Supreme Court, but my mother is here today. I would like to introduce some of my many friends and family who are here today with me. My son Jeffrey and his wife Mary of Virginia, her mother Lisa Klein of Delaware, my daughter Mary Catherine and her husband Sam Jenkins of Alabama, and his parents Steve and Carla Jenkins of Arkansas, my son Will Cook of Alabama, my brother Steve Cook of Florida, also an Air Force veteran, my cousin Jamie Estes of Florida, my senior staff attorney Claire Veal, and my law clerk Alan Crisologo and his wife Caroline. I also want to thank my many friends and family watching back in Alabama, including my wonderful colleagues on the Alabama Supreme Court who taught me how to be a judge, and my former partners at my firm of 31 years, Balch and Bingham, who taught me how to be a lawyer. Most importantly, I want to thank Jesus Christ, my personal Savior, who is the reason I am here today. I'm honored to be here and welcome your questions.
God bless you. Now, Mr. Candubi. Push the red button.
Thank you, Chairman Grassley, for your kind introduction, as well as Ranking Member Durbin for welcoming me to the committee. I thank President Donald J. Trump for this nomination, which is a tremendous honor. Allow me to introduce my family, who came from Michigan to be with me. My wife of 27 years, Julie Tiber, my son Jonah, and my two daughters, Lucy and Georgia, as well as my sister Debbie. I would also like to acknowledge a gaggle of Michigan State College of Law alumni in the chamber. They are my former students who showed up here for their old professor. I'm incredibly touched by their support. If I didn't give you all A's, I'm sorry, I should have. Almost 30 years ago, I began my career in the city in private practice and then worked for the Federal Communications Commission. My practice focused on the remains of the old AT&T telephone monopoly, merger policy, and remedying anti-competitive behavior. In 2004, I was appointed assistant professor at the Michigan State University College of Law, teaching topics such as technology, antitrust, and free speech, and eventually earning tenure. Though starting with telephones, my work shifted from competition issues related to a new technology, broadband. And more recently, my attention shifted to another dominant telecommunications technologies, internet platforms, and social media. But this time I took a more active role, litigating cases concerning social media censorship of consumers and the protection of children. I was asked to enter the first Trump administration as deputy, later acting Assistant Secretary of Commerce for NTIA, the National Telecommunications and Information Administration, and served briefly as Deputy Associate Attorney General at DOJ. After the first Trump administration, I continued to work on cases, as well as scholarship and policy work, focused on protecting Americans' free speech rights and protecting kids from the power of dominant online platforms. I'm currently serving as General Counsel for the Federal Communications Commission. My career, centered around law's responses to market power, has taught me a few things. It is competition and innovation that best remedy market power. The amazing development I just described, from the AT&T rotary dial telephones I grew up with to AI-mediated online experience, happened because of free markets, because American antitrust enforcers chose to unleash competition and encourage innovation. Antitrust enforcement, therefore, should proceed with the greatest care. At the same time, vigilance is necessary. Consumers must be protected against market power that hurts consumers, and especially when constitutional rights are at stake. If confirmed, I will bring to the Antitrust Division what I've learned from my career as a public servant, academic, and lawyer. First, given its limited resources and this administration's commitment to affordability, the Antitrust Division must direct its limited resources to those pocketbook issues that matter most to Americans. For instance, food prices, and what I term the 3 H's: housing, healthcare, and higher ed. If confirmed, I will make these issues my priorities. Second, I believe despite the dizzying technological changes I've seen in my lifetime, the more things change, the more they stay the same. The Sherman Act of 1890, the foundation of American antitrust law, passed largely through the efforts of farmers and ranchers. They sought to combat the railroads and shippers and grain elevators who abused their anti-competitive position. Today, farmers and food producers face different anti-competitive threats, but the Antitrust Division must remain vigilant. Finally, I am committed to protecting everyday Americans against market power that would deprive them of their free speech rights and their ability to speak to their fellow Americans. The possibility of serving this country as Assistant AG humbles me. I look forward to answering your questions. Thank you.
Thank you, Mr. Candu. Now, Ms. Judge Cronin.
Good morning, Chairman Grassley and Ranking Member Durbin. Thank you for convening this hearing, and good morning as well to the rest of the committee. It is an honor to appear again before you. At my hearing about 6.5 years ago, I was introduced by Senator Lindsey Graham, who was chair of the committee at that time. I was thinking back this morning to the kind words he said that day. At the outset, I wanted to express my condolences to the committee. I know everyone is doing their jobs with heavy hearts. Over my 6 years on the district court and my long career as a federal prosecutor before that, I've come to appreciate the critical role of the United States Sentencing Commission. The commission's work is tremendously valuable as district judges perform far and away our most difficult task, deciding whether another person should lose their liberty, and if so, for how long and under what conditions. I am humbled to be considered for the commission. I'm joined this morning by my amazing wife, Michelle. I thank her for always supporting my career, and if I am fortunate enough to be confirmed, agreeing to let me take on this additional responsibility. I thank my mother, who raised me with my grandmother, and together they instilled in me any positive qualities I may have. My mother was at my hearing in 2020, but today she is home taking care of our 3-year-old son, so Michelle is able to join me this morning. I would like to acknowledge the wonderful judges that I had the honor of clerking for, Judge Barrington D. Parker of the Second Circuit and Judge Robert A. Katzman of the Second Circuit, whom we lost in 2021. And I thank my current and former colleagues, my family of outstanding law clerks and interns, and my long-term courtroom deputy, Megan Henrich, who is at home with her newborn. And I also should note that some of my clerks and interns are here today, Ben Kessler, Dory Fife, Hyungju Han, and Abby Garden. And finally, I'm extremely grateful to President Trump for the trust he has placed in me with this nomination. I look forward to answering the committee's questions.
Thank you, Judge. Mr. Mannion.
Good morning. Thank you to Chairman Grassley, Ranking Member Durbin, and the members of this committee for holding this hearing. I want to start by thanking President Donald Trump for the honor of this nomination. I am proud to have served in his administration, first at the Justice Department and now on the White House Task Force to Eliminate Fraud. And I'd like to thank a few people who helped make that possible: Attorney General Pam Bondi, Acting Attorney General Todd Blanche, FTC Chairman Andrew Ferguson, and Vice President J.D. Vance. I look forward to continuing my public service on the Sentencing Commission if I am fortunate enough to be confirmed. I started at the Justice Department during the previous administration as a career federal prosecutor in Cleveland, Ohio. In that role, I litigated dozens of complicated sentencing guidelines issues, both in district court and on appeal. My service as a federal prosecutor gave me a deep appreciation for the important role that the Sentencing Commission can play in our criminal justice system, including by implementing new sentencing legislation from this body, resolving circuit splits that arise in the lower courts, and responding to Supreme Court decisions involving the guidelines. It would be a great honor to serve alongside Judge Cronin and the bipartisan group of commissioners led by Chairman Reeves, who currently serve on the commission. In closing, I want to express my gratitude just to be sitting here today. I have lived the American dream. I grew up a poor kid in the middle of cornfields in central Ohio. The closest town had a couple stoplights, fewer than 2,000 people. I certainly would not be here today except for the blessing and grace of God and the help and generosity of far too many people to count. But a few of those people are here with me today, and I'd like to briefly recognize them. First, my parents, Joseph and Cynthia Mannion, are here, and they instilled in me faith, patriotism, and a strong work ethic, and for that I am really grateful. Second, I'm joined by several colleagues from the Justice Department and the White House, whom I've been lucky to serve alongside, and I appreciate their support and friendship. Finally, certainly not least, I'm joined by my wife, Sarah Welch, who also serves in the Justice Department. She's an extraordinarily good lawyer, the best life partner I could ask for. Thank you again to the committee for holding this hearing. I look forward to answering your questions.
Thank you. Mr. Candia, you mentioned in your opening statement some of my first question, but let's zero in. Farmers generally can't set prices they pay for inputs or the prices they receive for their crops. They depend on real competition among seed and other ag suppliers to keep costs down and make sure that there are multiple options to choose from. Smaller independent ag companies help provide that competition. When larger actors don't play by the rules, these smaller companies need to feel confident that they can speak with their members of Congress and report legitimate competition concerns to the federal authorities without fear of unlawful retaliation. How will the Antitrust Division help protect independent agriculture companies from unlawful retaliation for reporting possible anti-competitive behavior?
Thank you for the question, Senator. I'm from Philadelphia. I'm from Pennsylvania. We don't do much food production there, but my wife of 27 years is from Northeast Iowa, from Waverly, born and bred. Her great-grandparents were farmers, her grandparents were farmers, and her uncle still farms. In my many years of marriage, I have spent countless hours in the beautiful rolling hills of Northeast Iowa, and I've learned about the difficulties and challenges of farming life, of the dedication and hard work of our farmers, and what they do to make sure that we have food every day to eat. You can be assured, Senator, that these issues will be a top priority if I'm so confirmed. As I mentioned in my opening statement, it is the need to treat farmers correctly and to protect them from anti-competitive abuses. That was one of the motivations and the genesis of the Sherman Act.
Thank you. They need an honest referee. I hope you can be that. Also to you, I remain concerned about PBM consolidation, drug pricing, steering favoritism, and hidden competition. I'm also concerned about abusive drug company tactics that delay generic and biosimilar competition. How will the Antitrust Division use its authority to address this sort of anti-competitive conduct in prescription drug markets that especially harm rural patients and independent pharmacies?
As I mentioned in my opening statement, the issues that are most important to Americans, to everyday Americans in their everyday lives, will be the top priority should I be so fortunate as to be confirmed. And of course, healthcare is one of those issues. The problems and issues that you discussed about drug pricing will be a priority of the division, should I be so confirmed. And I look forward with working with your office to help out the American people.
Justice Cook, please tell us what you've learned as a state judge that you'll take with you to the federal bench.
I hope I've learned judicial humility, Mr. Chairman. I've learned I don't know everything, and I need to listen very carefully in every case. I tell my law clerks when they come in every year, our job is to make sure we get the answer right. And that may mean reading every single page of the record. It may mean double-checking the research that we get. It may mean doing independent research. Our job is to get the answer right. And so I've learned when I first read the briefs, I'm going to have my mind changed often.
I'm going to have Senator Britt take over now, and congratulate all of you. I'm going to go to another committee to ask questions. Senator Durbin.
Thank you very much, Mr. Chairman. Judge Cronin, the Sentencing Commission is focusing on reducing sentencing disparities and promoting transparency and proportionality in sentencing. And certainly one of the elements of that is the issue of race. You wrote an article in 2001 in which you claimed it was, quote, easy to forecast whether a prison inmate will become a sexual aggressor or victim while incarcerated based on physical characteristics, socioeconomic status, criminal history, and other factors. You wrote, and I quote, black inmates are predominantly members of lower economic classes, end of quote. You also wrote, quote, black inmates are most likely to become sexual aggressors, end of quote. I'm deeply troubled by these statements in light of the position which you're seeking. Why should people of color believe that you've changed from the statements that you made in 2001?
Senator, let me say a few things about that. First of all, you're referring to an article that I co-authored back in law school. I believe one of the quotes there, and I have not reread this article in a long time, was a survey of studies that my co-author and I did. The statistic that you mentioned was not our study. We were quoting another author's study. I recall.
Do you believe that?
Do I believe that?
What you published?
Do I believe the accuracy of that study, or I'm sorry,
Do
Senator?
you believe the conclusion of that study?
I am not in a position to opine on the conclusion of that study, but I certainly do not feel that black inmates are more violent than white inmates. The point of that article was that prisons can be violent institutions and that prison officials need to be mindful of that risk. Now, in terms of my service on the bench, I think it speaks for itself. Over my 6 years on the bench, I've treated everyone before me as individuals and equally under the law. I treat them equally regardless of their race, gender, religion, or any other immutable characteristic, Senator.
Mr. Kandub, thanks for dropping by my office. We had a good conversation, I thought, and I raised a question about some of the partners you've chosen to write commentaries and articles in Law Review. In 1994, you wrote a Law Review comment in which you extensively criticized the landmark Violence Against Women Act. You also extensively discussed rape in your comment, at one point writing, and I quote, feminists have advanced the theory that rape is an act meant to perpetuate male domination. And the quote, the feminist claim seems difficult to maintain in light of the growing body of empirical evidence coming mostly from researchers of sociobiological bent that rape has sexual and reproductive motivations. Do you still oppose the Violence Against Women Act?
Senator, that was a student article, I haven't really thought about the issue, but the Violence Against Women Act has been here for decades, and I think it has served America well.
The quote I read was 32 years ago. Let's get recent. 3 years ago, in a 2023 interview with a right-wing Hungarian news magazine, in which you failed initially to disclose to the committee, you said, and I quote, the ideological bias of universities, the extensive harassment laws that regulate the workplace, and the gradual spread of self-censorship are leading to a society in the United States that is intellectually more comfortable, duller, more deceitful, and more timid. Timid was your word, than in previous decades. So let's clarify your position. Do you oppose laws that protect against harassment in the workplace?
Absolutely not, Senator.
Why did you say that anti-workplace harassment laws are leading to a society that is, quote, more comfortable, duller, more deceitful, and more timid?
I have spent much of my career as an academic. And for me, the most important part about being an academic is the ability to exchange ideas freely. Sometimes I think we have seen in campuses situations in which over-enthusiastic bureaucrats and enforcers can chill free speech. And I think that was my impetus. I want to protect free speech on
Do you
campus.
stand by your words?
Which word, Senator?
Do you want me to read it a third time? That harassment laws that regulate the workplace make the United States more comfortable, duller, more deceitful, and more timid than in previous decades?
I stand by my words because I believe in free speech.
Thank you, Madam Chair.
Senator Kennedy.
Yes, sir. The state action doctrine means that normally a private actor is not subject to the Constitution. It has to be something done by the state, whether it be the state or the federal government.
Right. And why is that?
It's because the Constitution relates to the government rather than to individuals. The Constitution is supposed to protect individuals.
Does that mean that a private actor can never be successfully accused of violating my constitutional rights?
No, Section 1983 is a statute, and it has it says that if someone's acting under color of law, even if they're a private actor, they can be violating your constitutional
What if
rights.
Section 1983 doesn't apply? What if it's just well, let me put it another way. Let's suppose the White House under a particular president called Google. No, I'll strike that. Let's call Facebook and said, if you don't stop publishing comments that question the COVID vaccine, we're going to punish you the rest of your natural life. And Facebook says, gotcha, we'll stop. And they do. Now, Meta, Facebook, it's a private actor, right?
It is, Senator.
Can I sue them if they take one of my comments about the COVID vaccine off as a violation of my rights?
I believe if the private actor is actually in active conspiracy with the government, they could be sued as acting under the color of law.
Yeah. What's the standard? What does color of law mean?
It means that that they're acting as if they were the government, Senator.
Okay. Well, let's take a public utility. They're heavily regulated by the government. Are they a government actor?
No, sir.
Why not?
Because they're a private entity, and that doesn't mean they're not heavily regulated. They're not subject to all the statutes the government can pass. The government can impose all kind of requirements on them, but they are a private entity.
Okay. You know the law, don't you, Judge?
I hope so. I'm glad I'm passing this National Bar exam.
Mr. Kandub, am I saying your name right?
Yes, you are, Senator.
Mr. Kandub, you're general counsel of the FCC.
That is correct, sir.
All right, explain to me like you're talking to a 10th grader what business it is of the FCC if a television network criticizes a political figure.
Senator, as general counsel of the Federal Communications Commission, I don't think it would be appropriate for me to venture into that issue.
I do. Explain the law to me. I mean, why doesn't I mean, this stuff scares me. Yeah, sometimes the FCC scares me right now. I don't like some of the stuff that is said on television, but why doesn't what business is it of the FCC? Educate me.
Radio and television broadcasters hold licenses from the federal government through a scheme that this body created beginning in 1927 in the Radio Act and then carried on in 1934 in the Communications Act.
Well, we haven't given the FCC the right to regulate freedom of speech, have we?
You have required the FCC to regulate broadcasters pursuant to the public interest.
And who decides what the public interest is?
It is the judgment of the FCC following precedent and following the law.
Doesn't that scare you? What if the FCC is in the hands of someone whose politics you disagree with?
Senator, as General Counsel of the Federal Communications Commission, it's my job to follow the law. I will do so in good faith, carefully studying precedent and applying the law to the facts.
Okay, I'm sorry, Madam Chair. All I'm saying is, y'all be careful. You're
Understood.
You're getting into the foothills of violating First Amendment.
Understood, sir.
Thank you for
Thank
the
you, Sen-
indulgence, Madam Chair.
Thank you, Senator. Senator Welch.
Thank you. I'd like to just continue that line of questioning from Senator Kennedy. I share his concern. I mean, my understanding is that the president, who had been a political candidate against Kamala Harris, was complaining about favoritism on a CBS interview of Kamala Harris. And FCC, Mr. Hendub, opened an investigation. Is that right?
Thank you for your question, sir, Senator Welsh. As General Counsel of the Federal Communications Commission, I think it would be inappropriate for me to discuss that matter. It's an ongoing matter.
Well, did you or did you not at the FCC open an investigation? That's public information, isn't it?
Again, I would have to check to see exactly the status of that case. But
I'm not asking about the status of the case. I'm asking you, did you open an investigation? It's been publicly reported you did.
Again, as General Counsel of the Federal Communications Commission, I don't think it's appropriate to comment on ongoing matters.
Well, I'm going to give the answer that Senator Kennedy gave. I do. I mean, it's publicly reported that you opened an investigation. You're denying that, or you just won't say?
I'm not denying that, sir.
All right. So with not asking about the details of this investigation, an investigation about bias, what was the basis? What would be the basis of you opening that investigation?
Again, as General Counsel of the Federal Communications Commission, my job is not to make policy. My job is simply to advise the chairman and the commission as to the advisability
Right, I'm
of...
commissioner of FCC, and I say to you as general counsel, I want to investigate this. What are the parameters by which you would evaluate whether my request as your boss to open an investigation about a report on a major network should be done or not done?
Again, Senator Welsh, as General Counsel of the Federal Communications Commission, my job is to give legal advice about possible alternatives.
Do you think that there's a chilling effect on political speech if the agency that has the capacity to take away a license decides to open an investigation?
Again, Senator, I'm
I'm not asking you your capacity. You know, if the FCC has authority to issue licenses and even revoke them, right?
That is the authority that Congress gave the Federal Communications
So the
Commission.
answer to that is yes.
Yes, that's correct, sir.
All right, so if the FCC that has that authority goes after CBS, ABC, NBC because it wants to, quote, investigate something, is there no consideration given by the General Counsel of the FCC that this has significant chilling impacts on the broadcast networks?
Senator, as General Counsel, I give legal advice, much of which is protected by attorney-client privilege, as well as other legal and professional obligations.
Civilian equivalent of taking the fifth. I'm not asking you about the investigation. I'm asking you about public policy. All right? I'm asking you about public policy. There's fierce political debate on this committee. Senator Kennedy and I oftentimes disagree, but neither of us gets punished because he's wrong. But I'm very serious. We have got a situation here where people have strong points of view in this country and they express them. And should a person be subject to governmental action because a governmental agency or even the President of the United States doesn't like the opinion they're expressing? Should they?
Senator, as general counsel.
I'm not asking as general counsel. I'm asking you as citizen Kandub.
But I am still general counsel of the Federal Communications Commission. I'm under numerous legal, professional, and ethical.
You haven't been made mute because you're the general counsel. I'm asking you as a citizen, is there not a chilling impact when a government agency with enormous power opens an investigation when it doesn't like the words that come out of the mouth of Senator Welch or Senator Kennedy?
This is an issue that implicates pending matters before the Federal Communications Commission. It's inappropriate for me to comment.
My time is up. Thank you, Mr. Chairman.
Thank you, Senator Welch. I'd like to enter into the record a press release supporting Mr. Kandub's nomination from the National Association of Broadcasters. This group praised him and stated, quote, as General Counsel of the Federal Communications Commission, Mr. Kandub has brought deep legal, regulatory, and competition policy expertise and experience, and we appreciate his thoughtful engagement on the issues local broadcasters face in today's media marketplace, end quote. Without objection, I will enter this into the record. Mr. Hawley.
Thank you, Madam Chair. Thanks to all the witnesses for being here. Congratulations on your nominations. I'd just like to note for the record, I'll count against my time, that Senator Welch voluntarily stopped when his time expired. Something I've never seen, or rarely on this committee, and certainly, as the ranking member can attest, something I have never done in my life.
Well, I
when
object
my time
to
expired.
that. I object that he was on time.
All right, well, I'll try not to make that mistake. Mr. Kandub, I enjoyed our conversation the other day, and congratulations on your nomination. Let's start, if we could, by talking a little bit about antitrust and individual liberty. Something that you said recently caught my eye. You said antitrust law, and I'm going to quote you now, can combat dominant firms' baleful effects on democratic institutions such as free speech, the marketplace of ideas, and shareholder control. I assume that's still your opinion.
It is, Senator.
I take that to mean that antitrust analysis under federal law is not therefore limited to consumer price. Is that a fair inference?
I support the consumer welfare standard, of course, but it can be measured by other things than simply price.
Yeah, and this is my point. I mean, the Sherman Act protects competition by outlawing a restraint of trade and monopolization more broadly. It nowhere mentions consumer welfare. Now, courts, of course, have constructed the consumer welfare standard, but antitrust laws apply to products that are ostensibly free to consumers. Would you agree with that?
I believe so.
So let me just ask you, how do you think the antitrust division should assess competitive impact in markets that are dominated by tech firms that do not have readily comparable market prices? In other words, that hold out their products much of the time as being completely 100% free.
Certainly, I would always look to ensure that there is an actual anti-competitive harm, which would require using the traditional tests of market power, and I'm not at all interested in abandoning them. However, I do believe, as you pointed out, Senator, that there are instances in which our civil rights, particularly free speech, can be at issue, and in those situations, the division should act to protect Americans.
Is it fair to say then that under your leadership, the division would not treat this claim that the price is zero as a reason to close an investigation into a dominant platform?
Zero pricing goods like social media present a very interesting and puzzling, sometimes to economists, challenge on how to value that. However, I do not believe at all that simply because something is zero price that it necessarily escapes antitrust scrutiny.
Good. Okay, good. I think that's a very important principle to get established because that is, as you know, the common defense of all of these tech companies as to why they should elude any antitrust scrutiny at the outset. Let me ask you about another implication of antitrust. In the social media market, there are roughly 3 firms, maybe at most, that dominate overwhelmingly the content that reaches the average 12-year-old in this country. Now, I'm a father of 3 children, all that age and younger. Let me just ask you, do you regard that kind of concentration as properly the concern of the Antitrust Division?
Certainly. As we all know from our antitrust classes, bigness is not necessarily bad. Concentration is but the first step, but it's the first step. And markets that are concentrated will, of course, get the attention of my division, should I be so fortunate as to be confirmed.
Good. That's exactly what I'm driving at. And let me just give you the perspective of one parent, which is that when there's no competition for parental controls, no competition out there that would allow a parent to choose greater safety for his children or her children, then you're leaving essentially the parents totally at the mercy of the platforms. In this case, the fact that there's just 2 or 3 dominant platforms, none of whom have any real interest, let me just call it like it is, any real interest whatsoever in protecting children online. In fact, who have a massive financial interest in pushing the most exploitative material possible, and certainly the most addictive material possible, to all of our children online, because it benefits them financially. You know, that leaves me and millions of other parents like me nowhere to go. And I think the fact that there's no robust competition is a huge part of this problem. I would just like to ask you if you will commit to coordinating with the FTC, which has some jurisdiction here, as well as state attorneys general, to prioritize child safety online. Will that be a priority for you?
Absolutely, sir.
Good. Well, my time has expired, and a radical departure from my normal practice, I will cease and desist here. But I will have questions for the record. I'm sure other folks on the panel are just devastated I didn't ask you questions, so I'll give you some questions for the record as well. Congratulations to all of you. Thank you, Madam Chair.
Thank you, Senator Hawley. Senator Blumenthal.
Thanks, Madam Chair. Judge Cook, who won the 2020 election?
A joint session of Congress certified that Joseph Biden won the election, and therefore, as a matter of law, he was the winner, Senator.
How many times have you rehearsed that answer with the White House?
I actually never spoke to the White House about that answer, Senator.
You knew what the answer was going to be because you've watched all the others give that canned, pre-planned answer, correct?
I have watched a lot of videos.
You have
Senator.
watched everyone before you, and you know what the routine is and what the President of the United States expects you to say, regardless of whether it is the truth or not, correct?
Again, I've watched a lot of videos, and I'm trying to be very precise.
Who won
Senator.
the popular vote in the 2020 election?
So if you look at each state, the governor, under one of our acts, is required to certify.
So you're essentially unwilling to tell me who won the 2020 election, who won the popular vote. Judge Cronin, you're already on the district court. Who won the 2020 election?
Senator, under the constitutional system, and in particular the 12th Amendment, Joseph Biden received the majority of the Electoral College vote.
You really have nothing to lose. You're on the court with a lifetime appointment, and yet you're unwilling to state the simple fact that Joe Biden won the 2020 election.
I do have life tenure, Senator. I'm trying to answer your question as truthfully and accurately as I can.
Mr. Mannion, who won the 2020 election?
Senator, I agree with the substance of my co-panelists.
Mr. Kandub, who won the 2020 election? Let's see if you can do better.
I agree with my panelists.
You agree with your...
The fellow panelists. The United States Congress certified Joseph Biden.
What kind of enforcer are you going to be if you can't tell the truth to a committee of Congress? And don't tell me that you can't answer because you're general counsel of the FCC.
The United States Congress certified Joseph Biden as president.
Judge Cook, was the Capitol attacked on January 6, 2021?
Yes, there was a lot of violence and vandalism at the Capitol and attacks on law enforcement. So I hesitate to use the word attack just because it would be something that would apply to everybody, and I believe in precision.
So you're unwilling to say what Justice Coney Barrett has said, what Judge Kelly has said, Judge Lamberth has said, federal district court judges and a Supreme Court justice, that the Capitol was attacked. You're unwilling to say that.
I actually don't think I quite finished my answer, Senator. I don't have a problem with saying some of those people attacked the Capitol, and there was vandalism, and there was violence, and they attacked law enforcement, and I denounce all of that. So yes, Senator, I don't think we're disagreeing.
Judge Cronin, what's your answer to that question?
Senator, from watching videos, law enforcement officers were assaulted. From what I saw, the Capitol, there was trespass, there was vandalism. So I would stand by what I observed, which I think made clear that there were assaults on law enforcement officers.
Mr. Mannion?
Senator, I agree. There was certainly violence against law enforcement officers, violence against the Capitol, and I detest all such violence.
Mr. Kandu?
I agree with my fellow panelists. It was a terrible day for America. There was violence against law enforcement, which I deplore. There was vandalism. It was a terrible day.
The violence against those brave Capitol police officers was because there was an attack on the Capitol and an attempt to stop the lawful transfer of power. For you to refuse to say there was an attack on the Capitol simply because Donald Trump characterizes it as a, quote, innocent journey is disrespectful to those police officers. It is also fundamentally disqualifying for a federal district judge or anyone else seeking a position of trust. It is chilling that people who've been nominated for this extraordinary position of responsibility would be unwilling to acknowledge the truth. And I was with a number of career prosecutors in the Department of Justice, former prosecutors who were responsible for pursuing cases relating to the event of January 6th just this morning, and received from them a letter that has been written to all the members of the United States Senate. I ask that it be entered into the record.
Without objection.
They say, and I agree, quote, this institutional denial of truth, especially by potential federal judges, is dangerous. Yet it's become all too clear that President Trump expects his nominees to provide evasive answers about both the attack of January 26, 2021, and the results of the 2020 presidential election. It is about the independence that you should be expected to demonstrate today on the bench and in all of the positions that you have been nominated to fill. I'm disappointed that you've avoided that responsibility. Thank you, Madam Chair.
Thank you, Senator Blumenthal. Senator Booker.
Mr. Kandu, in any other administration, this hearing would be straightforward. We'd be discussing antitrust law, competition, consumer welfare, but this is not a normal administration. This is an administration where the president has repeatedly treated the powers of government as instruments to reward those who help him and punish those who oppose him. We've seen companies attacked because of their news coverage. We've seen the president weigh in on mergers before independent review was even conducted. We've seen companies seeking government approvals, simultaneously resolving private disputes with the president himself, paying him millions of dollars. We've seen law firms, universities, and corporations pressured after becoming presidential targets. We've seen career public servants sidelined after refusing political demands. Again and again, the message has been the same, Mr. Kandub. Please the president and the government will work for you. Cross the president and the government may work against you. That is exactly why the independence of the antitrust division matters even more. You said to me in our private meeting, this is about consumer protection. It's about competition. It's about free and fair markets. But we know it's not about that in the antitrust division. The facts are plain. Gail Slater and 2 of her deputies followed the facts and the law and brought suit to block the HPE-Juniper merger. When Trump-aligned lobbyists went over their heads, they secured a sweetheart deal. And Gail Slater, who objected to the settlement, was fired. In the Stanley Woodard and Todd Blanche, who would be your bosses, cleared a $111 million Paramount-Warner merger without any conditions at all. Staff who reviewed the transaction before they could even issue a formal recommendation, they were going to recommend blocking the merger. You can even look at the Live Nation Ticketmaster. Career attorneys were in federal court alongside a bipartisan coalition of state AGs fighting that massive dominance of that venue ticketing conglomerate when senior DOJ officials bypassed them and negotiated a backdoor deal after the president met with the CEO. This is why it's important for us to know, will you follow the facts and the law? Will you listen to career staff? Or are you going to follow the dictates of a president who's shown over and over again that he's going to abuse his position to influence the law? So everything comes down to a simple question. It's not matter whether you know antitrust law. It's whether you have the courage to tell this president no when it's hard. So let me make this easy. Show us your courage. Show us your independence. Be a man, be your own man right now and stand up and answer a question, yes or no. A simple yes or no question that shows right now all of America that you're your own man. I don't need legalese. I don't need trickery. Yes or no. Did Joe Biden win the 2020 presidential election? Yes or no?
The United States Congress.
Oh, there you go. Sir, stop. Federal courts said he did. President's own attorney general said yes. President's own cybersecurity director said yes. Republicans all over this country said yes. And right now, you're not showing me. You can't even acknowledge a fact that's been established by the courts, the president's own attorney general, by his own election security officials. Why should we believe that you're going to stand up to this president when billions of dollars are at stake and the fate of mergers are in your hands? This is the pivotal question. Can you please tell me a yes or no answer? Tell me no, I can't give you a yes or no answer if that's your answer. Yes or no, did President Biden win the 2020 elections?
The United States Congress certified Joseph
Sir,
Biden.
you are showing cowardice. And that's the question. Are you going to choose the truth or Trump? Law or his lies? Or are you going to choose the Constitution or cowardice? Let me ask you one final question to maybe bring this into light and show me that you're your own man. I'm asking this very simply. Show me or tell me one single occasion, publicly or privately, where you pushed back against this president. One time, after he suggested that government decisions should be guided by his personal political interests, can you tell the American public, I know you and your wife probably don't agree on 100 out of 100. I have a litany of things I disagree with Biden and Obama on. Give me one thing that you thought the President of the United States has done that you think is wrong, untoward, corrupt, policy disagreement. One thing for the American public. Here's your chance. Show me you're your own man.
I've always, in my government capacity, and I look forward to doing so, to make all of my decisions according to the law and the facts.
Sir, stop. This is a game. This is really a game. American people have the right to be concerned that this president, through the facts of the Antitrust Committee, is going to use his power to influence you in your job. I'm not asking you to come out against the president. I'm not asking you to go against the truth. I've given you opportunities here to show us in the easiest questions possible that you're your own man. And you haven't given me one shred of evidence that you can stand up and choose the truth over Trump, the law over lies, the Constitution over his continued corruption. I'm disappointed. I was looking for one thing to show independence. You told me in my office, I will be independent. And this is disappointment that you can't give me one example of you differing with a person that most of America knows, has lied repeatedly in his office, has taken on policies that have been detrimental to the independence of the judiciary. And I'm not going to support your nomination. Thank you.
Thank you. Senator Lee.
Thank you, Madam Chair. Mr. Kandub, I'd like to start with you. I'd like to hear just about your overall philosophy regarding antitrust enforcement.
As I've mentioned, I will apply the law to the facts. That means judicially weighing the facts, consulting with the career staff, developing the legal theories, and then using my own judgment to come to the best solution to the problem. Antitrust is a very blunt instrument. It can do a lot of damage as well as a lot of good. But I think that if I'm confirmed, I will be very cautious. It's humbling. The wrong decision can hurt American lives. The right decisions protect competition. And I will take the decisions that I'm presented with the greatest care, recognizing their tremendous significance.
Is bigness disfavored or presumptively suspect under antitrust law?
Absolutely not. Bigness in and of itself is not necessarily indicative of any antitrust harm. In fact, bigness often provides efficiencies that are valuable to the American people.
Now, there are those who are skeptics of our antitrust laws who like to say, I believe in the free market. I want the free market to take care of this. Government shouldn't intervene in antitrust law. What's your best response to that?
I would say they're right. Free markets generally have the answer. As I mentioned in my opening remarks, what has been so wonderful about American antitrust enforcement is that it has recognized, it has unleashed competition. It has recognized that markets can adjust. Often antitrust settlements cannot. And therefore, for government to introduce into the economy its own vision of what is the right outcome is very dangerous. The amazing economy we've had for 250 years, is because we allowed free markets to do their work.
Right. So taken to its logical conclusion, one could take that and say, okay, then let's not enforce our antitrust laws, or let's enforce them with rarity and with extremely narrow, careful stripes, or not at all. What's your response to that?
Well, I would be on the let's do so, but the evidence must be strong. As I said, it's a blunt instrument. It can do harm, but when the evidence is there, I just enforce the law if I'm so confirmed. It's not my job to make it. It's there, and the law will be enforced. And it does. And as I mentioned earlier, protecting competition, ensuring that our market structures maximize social welfare is the goal of antitrust.
Okay. So if bigness isn't the triggering issue, what is? What is the central touchstone, insofar as you can boil it down to one standard that applies more or less in different antitrust contexts?
The only coherent standard that ensures that in any antitrust decision you're benefiting all Americans is the consumer welfare standard. Okay. Because that is the only one that ensures that there's more stuff, more outcome, more utility, rather than less. So that is the touchstone. It doesn't mean that there's certain circumstances that we can have an expanded, or not expanded, but a view that does not just focus on price, but that is the only coherent way to look at antitrust law.
Because consumer welfare doesn't exclude other considerations beside price, correct?
Absolutely not. It can include things such as privacy, or I would say, when constitutional rights are at issue, like free speech.
To what extent and what ways do you think state attorney generals should play a role in antitrust enforcement?
If confirmed, I hope to work with state attorney generals to have a coherent and consistent antitrust enforcement.
Are you aware of any other country, or at least any other peer or near-peer nation, any other developed nation that has antitrust laws, competition laws, if you want to define it more broadly, that has two antitrust enforcement agencies that are not connected to each other?
To be honest, I'm not an expert on comparative antitrust institutions.
Neither am I, and I'm not fishing for any particular answer. But
to be honest, Senator, I just don't know.
Yeah. All right, I'm out of time, but these are things that need to be considered, including what happens when we end up with a two popes problem. If you try having two popes at one time, it doesn't work. If we had two presidents of the United States serving simultaneously, that would cause other problems. And I think one day Congress needs to grapple with this and figure out whether it makes any sense to have these twin, siloed, parallel universe antitrust enforcement agencies that often determine jurisdictional battles by a coin toss. Thank you.
Thank you, Senator Lee. Senator Schiff.
Thank you. Mr. Cook, in 2008, Barack Obama ran against John McCain. Who won that election?
I believe President Obama was sworn into office, so I'm certain he won, Senator.
And John McCain lost that election?
Yes, Senator.
4 years later, Barack Obama ran against Mitt Romney. Who won that election?
President Obama was sworn into office, so I'm certain he was elected as a matter of law, Senator.
And did Romney lose the election?
That's the natural, logical converse of that, yes.
In 2016, Donald Trump ran against Hillary Clinton. Who won that election?
He was sworn into office, so as a matter of law, he was elected to that office, Senator.
So Donald Trump won that election?
That would be the natural assumption, yes, Senator.
Well, isn't it really an assumption you have to make? Did Donald Trump defeat Hillary Clinton?
In the Electoral College, he did, yes, Senator.
Do you have some uncertainty about whether he won that election?
No, I'm trying to be precise about what I'm saying. Yes, he won in the Electoral College because...
And Joe Biden in the 2020 election, who won between Donald Trump and Joe Biden?
Well, Joe Biden was certified by a joint session of Congress, and so as a matter of law, he was the elected president.
How about as a matter of fact? Who won that election?
He was. We implement the 12th Amendment, and under that, he was elected.
As a matter of fact, who won that election? Just as a simple matter of fact. Somebody asked you out on the street, who won the election in 2020? What would your answer be? Who won and who lost?
I would say as a matter of law, he was elected, Senator.
And as a matter of fact?
That
you're somehow separating the law and facts. As a matter of actual fact, who won the election in 2020?
It's a fact that the Electoral College vote was more for Joe Biden.
You seem to have real difficulty with that question. In 2024, Donald Trump ran against Kamala Harris. Who won that election?
President Trump had more Electoral College votes, and so the joint session of Congress certified him as the winner.
So Donald Trump won that election?
As a matter of law, he was elected, Senator.
And Kamala Harris lost that election?
That was the converse, yes, Senator.
And Mr. Kandeb, in 2016, when Donald Trump ran against Hillary Clinton, who won that election?
Donald Trump was certified as winner by the United States Congress.
Did he in fact win?
He was certified as winner.
Did he in fact win?
He was certified as winner.
Do you have some doubt about whether he won?
Well, under our constitutional structure, it is the states that have...
No, my question is, do you have some doubt about the outcome?
I have no doubt that the U.S. Congress certified Donald Trump as winner.
No, I don't ask you that question. Do you have any doubt that Donald Trump won the election?
I have no doubt that under our constitutional structure...
well, that's really not my question. In 2020, Who won the election?
The United States Congress certified.
Why is it difficult for you to answer a simple factual question about who won presidential elections? When did it become so difficult to answer such a simple question? And how can we expect you to rely on the facts when you're evaluating a case, Mr. Cook, when you're evaluating a merger, Mr. Kandab? How can we expect you to rely on the facts when you have such difficulty stating the obvious? Mr. Kandab, when you met with my staff yesterday, you said you stood by your previous comments, including op-eds you wrote for white nationalist websites like Vidare. In one of those, in an article titled "Immigration and Three Twitchy Jewish Nerves," you stated, quote, "Muslim immigrants and their children seem prone not only to terrorism but to cultural separatism." Do you stand by that statement?
Senator, I wrote that article in defense of Donald Trump's travel ban, which I thought was essential.
That's not my question. My question is, you told my staff you stood by your previous statements. Do you stand by that one?
I stand by those articles. They were defenses against terrorism.
So you stand by that statement. So what do you mean that Muslim immigrants and their children are prone to terrorism?
I wrote those articles.
I'm not asking you. You've already said you stand by that statement. So what do you mean by that?
I'm trying to explain. I wrote those articles in defense of Donald Trump's travel ban, which is to protect us against terrorism. And I thought that terrorism continues to be a tremendous threat to all Americans.
And you think that Muslim immigrants and their children are somehow prone to terrorism?
I wrote it in support of the travel ban.
I'm aware of why you wrote the article. My question is, and I would like an answer, do you stand by your statement that Muslim immigrants and their children seem prone to terrorism?
I stand by the article I wrote. The travel ban was being...
Well, then that's all I need to know. I yield back.
Thank you. I'd like to enter into the record a letter supporting Mr. Kandab's nomination from 22 former senior Justice Department officials, including former Attorney General Bill Barr. They endorsed Mr. Kandab and stated that, quote, "His government service has demonstrated the leadership and management ability the division's leadership demands. His private sector experience has given him practical judgment, and his academic work will guide him in addressing the important policy questions the department will face in the years ahead," end quote. Without objection, I will enter this into the record. And now for, it seems, your final round of questioning. I want to start with you, Justice Cook. We are so thrilled to have you here and very proud of the work that you've done, getting to watch you on the bench for the last 4 years. You have an impeccable record, both there and in your previous career there at the law firm, and obviously service to our nation, the Air Force, rising to the rank of captain in the Air Force Reserves. I heard you say you were going to take from that experience, particularly that on the bench, judicial humility and making sure that you're doing all of the work. I know that about you. You dig into every issue, every problem. You want to understand what's in front of you and make sure that you find the best pathway forward. On that note, I have also heard you talk consistently about you being boring and predictable. Do you mind telling my colleagues a little bit about your judicial philosophy and what you will be like on the federal bench?
Thank you, Senator. I do believe in public service. That's why I spent 4 years in the Air Force, and that's why I spent all that time on the campaign trail together, going to all 67 counties in Alabama and driving 80,000 miles because I believe in public service. And as you mentioned earlier, I've written a 2-volume treatise on the rules of civil procedure. It's frankly a boring book, but it's a great reference tool. And it reflects, like you say, that I'm a boring and predictable person. But I've accumulated 35 years of experience now between my time in the firm and my time on the bench, and I want to be able to bring that service and that experience and that knowledge to bear in the federal system. And I think I can help the wheels of justice move efficiently and justly, Senator.
Thank you so much, and thank you for your willingness to serve. Can you talk about how you approach novel questions of law, both on your time on the bench currently at the Alabama Supreme Court, and what your approach might be if confirmed here to the district court?
Well, on the Supreme Court, if I get a novel issue, I'm always looking at the text. The text is always the first thing you look at, and you look at the original public meaning of the text. What did the words mean the time they got passed? Because the subjective intent of the legislators is really not relevant. What we care about is for the words they passed. That's part of the separation of powers, is that we enact the laws, and then I determine our court determines what the law is. We don't determine what it should be, we determine what it is.
And tell me this, what qualities, now that you've had 4 years on the bench, what qualities do you think are most important for a judge to have?
Well, you need to be impartial. You need to be firm that you're not going to bend. You're not going to worry about the pressure or the consequences. You're going to get the right answer. You're going to be willing to keep researching, and you're not going to stop until you're certain that you got the right answer. You're going to dig and dig and dig, and you're going to be willing to change your mind if you have to change your mind to an answer. And like I say, my fellow colleagues in the Alabama Supreme Court have helped teach me to be a judge, and those are the type of things I've learned from them.
Excellent. In our last remaining minutes, I'd like to ask each of you, take 15 seconds and tell us something that you want to make sure that this committee knows about you prior to making the decision. We'll start with you.
Thank you, Senator Britt. I care a lot about the Sentencing Commission and the sentencing guidelines. When I served as a federal prosecutor, I saw how important they were in each case. I'm also very aware of how important it is that they be written and revised in a way that makes it easy for prosecutors, defense attorneys, and judges across the country to apply them in the various cases they encounter.
Thank you.
Senator, over my time on the bench and as a prosecutor, I've come to realize the importance of the Sentencing Commission in our criminal justice system. Those are for some of the reasons that Mr. Mannion just mentioned. The U.S. sentencing guidelines, which are an important factor under Section 3553A and are most valuable when they accurately or at least effectively capture the offense and the offender. And I would be committed to carefully examining the guidelines and see how they can be improved to account for as many of the 3553A factors as we can. The other important role of the Commission is its unbiased collection of data and information that is vital to this body as you perform your task in considering criminal justice legislation, and also to sentencing judges as we try to impose sentences that are sufficient but not greater than necessary to achieve the purposes of sentencing.
Thank you.
I've been working on competition issues my entire life, and I want to bring all the energy and commitment I have to making sure that the American people get great deals.
Thank you. And Judge Cook.
I'm just incredibly honored to have the opportunity, Senator, and I just want to thank you and the President for that opportunity.
Absolutely. Well, thank you to our nominees for being here and for your testimony today. Written questions for the record may be submitted until August 19th at 5:00 p.m. And with that, this hearing is adjourned.